Good afternoon. In this review, I just want to do, or in this video, I just want to do a very short review of what we covered over the last couple of days. When we first started, we said that in order for there to be a violation of the Fourth Amendment, or a person to have the right to file a motion to suppress because there has been a violation of the Fourth Amendment, we must first find that the person has standing. That's something that we'll cover later in the topic or later in the course. After we find that the person has standing, we must find that there's governmental action. There's governmental action in two instances: when the person is one of the people that is protected by the Fourth Amendment. The people shall be secure in their rights and their person, places, homes, and effects against unreasonable searches and seizures. The people have been decided as those who are citizens and those who have significant relationships with the United States, such as they would be considered citizens or such as they would be accorded to rights or privileges under the Fourth Amendment. You can find that in United States versus Urquidez as Urquidez. The second thing that's necessary, the third thing I should say that's necessary if there's going to be a motion to suppress that will be successful, is that we must find that there was a search or a seizure. Under the Fourth Amendment, there cannot be an unreasonable search or seizure. And here, what we're talking about, the first thing that we talked about, what is a search? What is a search? And to find out or to determine what is a search, we went to Katz. Katz, if you remember, in the case of Katz, there was a person in a telephone booth talking close to the door, paid the toll, and talking into the receiver. The government believed that the person was involved in illegal gambling activity. They placed a listening device on top of the telephone booth in order to hear his conversation. The person complained that this was a violation of my Fourth Amendment right. The court found that yes, it is a violation of the Fourth Amendment right. First, they said that the fact that it was in a telephone booth, and telephone booth is a public place, does not matter. It's not the place that the Fourth Amendment is meant to protect, but it's a person. It's a person's right to privacy, the person's right to not be interfered with by the government. And the court went on to say that in order to make the determination as to whether there was a search, that there's a two-pronged test. And the two-pronged test came from the concurrent opinion that was filed by Justice Harlan. That two-pronged test said, number one, that in order for there to be a search, that the person must exhibit a subjective expectation of privacy. That prong is based upon what the person does. What does he do in order to protect his privacy? What does he do in order to show the public that I want this thing to remain private and not be revealed to the public or even the government? The second prong of the test is that reasonable expectation of privacy, a subjective expectation of privacy, I should say, should be one that society is willing to accept as reasonable. That is based upon what is reasonable. What does society expect? Would society say that these particular areas, these particular things are not subject to government invasion, that they should be protected by the Fourth Amendment, that we don't necessarily leave these things open to the public, we don't want to leave them open to the government? Does the society accept his subjective expectation of privacy? Do they accept it as one as reasonable? Also, we get from Katz, there's two other things. Katz also said that there's no expectation of privacy in illegal activity. Now let's go back to Katz. If you look at Katz, the person, Mr. Katz, was engaged in illegal gambling activity. However, it wasn't the illegal gambling activity that caused this case to fail. Or maybe I should say that even though he was engaged in illegal gaming activity, the method in which the government was able to uncover or to reveal that illegal gaming activity was in violation of the Fourth Amendment. And so even if you're engaged in illegal activity, the government cannot violate your rights under the Fourth Amendment in order to determine or in order to get to the fact that you're engaged in illegal activity. Now, another thing that it brings out is that the government does not have to avert its eyes to illegal activity. That if illegal activity is open to the public, If the public has access to that illegal activity, the government will have access also. Now we moved on and we talked about Jones, and we said that there are two tests now in order to determine whether a person uh, whether the government has engaged in a search. Again, the first test is Katz. Jones says that the second test is totally different from Katz. The second test, Jones says, is different from Katz because when there is a physical trespass onto the property of a suspect or physical trespass onto the property of a complainant, then the government has violated the Fourth Amendment. That is, if there's a physical trespass onto the property of a complainant for the purposes of gaining information that's going to be used to prosecute that person in a criminal case, then the government has violated his Fourth Amendment, or the Fourth Amendment comes into play, I should say. Not necessarily violated because there's several other things that maybe that we probably would have to look at. But if there's a physical trespass and not one that's done electronically, Jones is applied. For instance, if we go back and look at Jones, they applied the system that they used to track the Jeep. They attached it to the car. The court said that the attachment of the GPS device onto the Jeep was a trespass onto that property. And so if there's a physical trespass onto the property of the complainant, then we will use Jones. Jones will become the test. Jones says, in essence, that we don't overturn Katz, that we only supplement Katz, because Katz was only meant to apply to electronic surveillance. If there's an electronic method that the government used in order to get that information for purposes of prosecuting, then you will use Katz. However, if there's a physical trespass, a physical attachment, a physical going on to someone's property by the government, then you use Jones. Jones and Katz, for our purposes, are only for the purposes of determining whether there's a search. Whether there is a search. Remember, the first thing we have to have, we have to have government action, have to have standing in order to file the motion to suppress, and then if you have governmental action and standing, then we must determine whether there is a search. And if there's a search or a seizure, then after that we look to determine whether there is a warrant and whether the warrant requirements have been met. But first you must determine whether there's a search. Jones says, we do not make trespass the exclusive test. Situations involve merely the transmission of electronic signals without trespass would remain subject to the Katz analysis. What the court in Jones did not do, it did not answer the question which really perturbed Justice Sotomayor as to how long could the government use that device, have the device attached to the car or to the Jeep of Mr. Jones for the purposes of getting that information. Listen to what the court said. It may be that achieving the same result through electronic means without an accompanying trespass is unconstitutional invasion of privacy, but the present case does not require us to answer that question. They said, and that question is not necessarily a part or an issue in the Jones case. Whether it was 4 weeks, whether it was 2 days, whether it was 6 months, they said that's not an issue. The issue in the Jones case was whether there was a search and not how long the search went on, or not how long the activity went on. Now, also in Jones, one of the things that they said is that once we determine whether there's a search, if there's a physical trespass, that is, the government has physically trespassed onto the property of the complainant. Once we have determined if there's a physical trespass, at that particular point, we must determine whether that trespass was reasonable. In order to determine whether the trespass is reasonable, we generally don't look to the warrant requirement, because what happened in Jones was they got a warrant, and then the warrant was determined to be invalid. And when the warrant is determined to be invalid, then we have to determine whether that trespass meets one of the well-delineated exceptions of the Fourth Amendment. or one of the well delineated exceptions, I apologize, to the warrant requirement. And we'll take a look at that as we go through the course. That's a whole new topic within itself. And so, okay, if there's a search, we have Katz if it deals with electronic devices. If they use an electronic surveillance device in order to get information for the purposes of prosecuting an individual in a criminal case, Katz. If they go onto a person's property, trespass onto a person's property, by trespassing, by walking onto, by placing something onto, for the purposes of gaining information that will be used to prosecute that person, we use Jones. Is it reasonable under Jones? Is it reasonable under Katz? And we'll look at some other cases for the purposes of determining, for the purposes of seeing how to apply this. We talked about open fields and we talked about curtilage, and I'll bring that up again at the beginning of the class. And when we return to class on Wednesday, I want to look at the two cases that we skipped, Florida versus Jardines and Riley. And so we'll talk about those on Wednesday. Have a good Martin Luther King holiday. Thank you. Goodbye.